The recorder is going, we're in the work session on the licenses for AlaskaSense. There are actually two, and they're in AR 2018-252 and 253. They are concerning marijuana licenses 10237 for cultivation and 10236 for retail, right? I'll do introductions first. Mr. Gates.
Dean Gates, City Council.
Becky Wynn-Pearson, Municipal Attorney.
Mandy Honest, Municipal Clerk's Office.
Eric Croft, Assembly.
Christopher Constant. John Middleton.
Ira Herman.
Steve Peterson.
Suzanne France.
Great. Go ahead, Austin.
Austin on the phone.
Excellent. Anybody else on the phone? All right. Austin, if somewhat difficult, but you just make some sound and we will get you recognized. I know a representative from the license holder is here. Is there anyone here for purely public testimony that is not representing either the municipality or the applicant? Okay. Yeah.
It's hard to hear on the recordings and probably for Austin if you're sitting far back. So if you're going to speak, and I hope you will, maybe move up to the front row.
Okay. Yeah, I told the applicant through their counsel that at the gave the option of giving some presentation, a brief presentation at the beginning or the end. This is a work session primarily directed towards us talking issues through, but we also want to be very cognizant of both the public's right to hear, it's an open meeting, to present their comments, and of course even more so for the person who's directly involved, the licensee here. So she'd like to speak at the end, the representative, and we'll allow that. I guess we should begin. I propose we begin. Is there anything attorney lawyer-wise we need to do first? You guys were conferring. That makes me nervous all the time.
Well, I guess I should, if I may, a quick statement at the beginning about work sessions and public discussion or comments. We have is a few times in past weeks. Work sessions are truly comedy meetings and simply meetings, and our past practice has been that we may have public comment but not necessarily required to. So, and as you just said, you were running public comments, so I guess that's the case for today's work session. Yeah, that was an important thing to mention at this time.
Yeah, thank you, Mr. Gates. And we want to involve the public to the maximum extent. We want to hear their comments. This was noticed on Thursday that we were going to be doing this. The resolutions that we're talking about have been on the website, Mandy?
Yes.
Have been publicly available. So, and there isn't any public here to speak about it. There is the representative, and we will hear from them. And so I want Mandy to present the materials, and then I guess I wanted to both open it up for assembly discussion on this license and what we might do, what people's concerns are. We can do all that in open forum. Because of this, but also with the ongoing experience with marijuana and alcohol licenses and the way we handle quasi-judicial items, that is, when we are being asked to act not solely as a policymaker, a Congress or legislator, if you will, but somebody who's determining, quasi, just lawyers love to throw around Latin, but it just means kind of like a judge, right? And so we're operating in that capacity, and different considerations, different rules ought to apply. Mr. Dunbar and I and Barbara and Lisa and Mandy are looking at, had a big meeting on it, and Dean, lots of bright people, and we're looking at whether there's a best practices to that. That is, we're thinking that we move it to another part of the agenda so that we focus on that we're in a different area and different rules apply. Maybe treating it clearly in our code in different ways that make clear when you can do ex parte communication or when it's not appropriate. When your own fact finding. A lot of us have gone out and walked around cultivation facilities to see if we can smell, right? Is that something that is a good part of our job or prohibited? Kind of be interesting for us to know when and where we ought to or definitely should not. how we get information and how people get to respond to it may be very different in those things. So we're obviously talking about this license, but we're also trying to figure out how we handle these things well in the future. So this work session is on both of those, if you will. How this license, what we want to do, and what we want to, how we want to try and handle these things in the future. Mandy, if you can present just the ARs that we have and the materials that people have here.
Yep. So for the 2S versions, these are on the addendum to the agenda, and these are kind of a different format than what you've been used to seeing for the marijuana ARs. Becky and Dean conferred with the clerk's office and really wanted to get a section in that solidified the facts and findings for the assembly to put on the record should they decide to protest or deny a license. So if you flip to the second page of either one of them, you'll see there's check boxes towards the bottom. So the first portion, that's section 2, is the general review that the clerk's office does with all of the other municipal reviewing departments. These are the review standards out of the general provisions for Title 10 that are done for all licenses. And then if you go down to the second set of check boxes, this is where the assembly would check, if applicable, any of these that are pertaining specifically to the marijuana licensing reviews. And this would be if there are any reasons to protest or deny the license. This would be your facts and findings.
Did you add has committed a violation, or we're still sort of thinking about that? There is the license, there's a violation of a condition or restriction.
Right.
Or the license, up earlier, the license is prohibited by municipal code. But is there this licensee has violated some stuff in the past?
So what we added on was the very last checkbox, the applicant committed prohibited acts referenced in section 10.5020.
Okay.
And that is out of the general provisions that they have violated any of the requirements of the title or of the license. So any of the requirements within Title 1080 of the license, if those have been violated, that's where that would fall under. And then
10.520 sweeps in 1080. It's sort of as a you can't have done a whole bunch of bad things.
yes, that's general encompassing all of Title 10.
Is that what you wanted to address?
I wanted to make a slightly different point, which was when Maidman and I spoke with the Community Economic Development Committee, which was if the grounds for your determination that you'd like to deny a renewal application are that there have been repeated violations in the past and that demonstrate a pattern of bad conduct by a licensee, I believe the most appropriate conclusion is the issuance of the license will adversely affect the health, welfare, and public safety of the neighborhood in which the marijuana establishment is proposed to be located, or otherwise would not be in the best interest of the public. And if you wanted to be more specific there, you could add that the assembly concludes that the six violations in the past year indicate a pattern of poor operator conduct, which fulfills this requirement, which is called specifically from 1080. So this is basically a reflection of code here, this list. And the code doesn't have a separate provision in 1080 that says you've committed an outstanding violation that's to grounds for denial of renewal. It has these more general provisions. But I do think it's legally sufficient to say there have been a series of violations that indicates that the renewal is not in the public interest.
Okay. Austin, can you hear Ms. Honest and Winnie Pearson?
Yes.
Okay, good. We'll all keep speaking up. Any assembly members who want to have this? I have Mr. Weddleton.
I have a couple of questions. So on this just deals with shall we send a protest to AMCO. It doesn't really say we're going to take action. Is that correct?
So it is protesting this.
Sorry, could you repeat the question? I can't.
Yeah, so I want to note that Mr. Weddleton told everyone to speak up, and he couldn't hear you. So speak up, Mr. Weddleton.
Move that speaker.
Yeah. Talk louder.
Technical problem.
So thank you, Austin, and appreciate your telling me to speak up. The question is, on this, we are simply sending a message to AMCO that we're protesting. So this doesn't, we're not taking an action against the license we give them.
And I think they were going to disagree.
Yes.
Miss Honest first. Yeah.
Yeah, so it does both. The ARs do protest the renewal of the state license. They also have the sections where there's conditions that haven't been met. So for one of the licenses, and this is for their cultivation certification from land use enforcement and
Okay, so we're looking at 252, and you're going to show us where it does both.
Yeah.
Yeah. Okay.
So 252, if you look, the fire department box is checked. And this is the municipal clerk has not received certification from these reviewing departments. So fire, and then the other is land use enforcement, and that's on the 3rd page. So they're being protested until we get certification from those. The second part to it is the assembly as a body does an overall review of the license as well. So you would be taking into account all of the other information that is pertinent to the renewal. And so that's that second part where you are able to check any boxes that you deem applicable.
Okay, so can I go on that question? Because I think it's a good one and confused me as well. So in the last section, which after all is what we are doing, like the beginning is very important, sets the stage, tells people why, what's lacking. But sections 3 through 8 are what we're doing. We say we protest the state license, that's section 3. 4 is we approve a temporary license, that's our license. 5 is we tell the municipal clerk, you can go ahead and give the municipal license if certain things happen, and they're listed above. And then 6 is if those things happen, the renewal lasts. If they don't happen, then it's denied. So 4, we can give them a temporary license. 5, the municipal clerk can give them a permanent one if these things happen. 6, the municipal clerk can just end it if they don't do those things. And 7 can send to AMCO various things, and 8 can also communicate with AMCO. So 3, 7, and 8 have to do with us communicating with the state about the state license, and 4, 5, 6 seem to do with us either doing or telling our clerk what to do on the municipal license. Go ahead.
So we could go through here and say this operation is not performing well, the train wreck, all kinds of horrible problems, but then look and say, well, shoot, the state cracked down on them, gave them tens of thousands of dollars of fines. That's pretty strong action. And while I agree that it's hypothetical, I'm saying, it's very, very bad, but they felt a lot of pain, and we did this with Nation Guard. We see that they've taken real serious action towards correcting things. So yes, they're bad, but we think in the future we'll give them another chance. Is there an opening in here for that?
I think you would need to. I think you need to do a floor amendment to specifically state that, right? Or but with Danish Gardens, didn't you? If I'm recalling correctly, wasn't it the same structure? It was a temporary.
Same, yeah.
So there, basically, you said simply resolve outstanding land use items.
And so that is as it is written now. So if you decided that the assembly didn't want to take any further action on the license as far as punitive action, then you would leave it as is, and they would have to get the certifications from fire and land use, and then you would delegate to the clerk's office to be able to issue the renewal licenses once those have been met.
Let me just reiterate so that everyone stays on the same page. I apologize if you're already ahead of me or there. But what she's saying in response to Mr. Weatherford's question, right, is essentially if you approve this, because we have checked in section 2 the fire and the land use, that's the only thing we're protesting. So we're saying as long as you get the fire and the land use fixed, clerk's office, go ahead and do. We're not issuing any other fines, and we're not taking any other action on your license. And that's partially because in section, also in section 2, we haven't checked any of these, take it away because and the most open is the adverse impact, but it has all kinds of other ones that are possible. So if we don't check any of those boxes and just do it this way, we are saying to this applicant, go ahead and do with a temporary license, and you can get your full license if you fix the 2 things we identified. Good. Well, I'm sorry, I had Mr. Peterson and then Mr. Weather. Did you want to go first, Becky?
Oh, I just wanted to, one minor clarification. I do believe that with Danish Gardens, if I'm recalling correctly, the provision with respect to the land use enforcement section was even more narrow. It wasn't a broad-based certification that was required. It was simply a certification that there were no outstanding fines that were unpaid. So if you were to do the same kind of treatment there, you would need to narrow it a little bit even more further.
Great, thank you, Mr. Peterson and Mr. Weddleton.
Thank you, Mr. Chairman. So I was wondering, what is the problem? Why hasn't the fire department passed this? Why haven't they passed the fire department?
So I do have an email to them. I never received the full inspection report. They just responded to the clerk's office saying that they were not going to certify it. And so I can get that information to you once they give the specifics.
Here's the applicant may have some information to give us on that, Mr. Chairman.
Yes, it does. Mr. Weddleton?
Do you want to get a quick answer?
No, did you?
So if I look at this on this last group of check marks, the 6th box, if we check issuance of the license law versus impact, what we mean by that is we revoke because. Is that what it means? That would be nice if it said more clearly, crystal clear. But we'll work with this time.
This is out of code word for word, so we can keep that in mind.
Okay, but that's what we're saying.
Yep.
We do that.
Yep.
So I mean, I will come back around. I wanted to do that in order. Yeah, did you have something on the fire permit?
It was that Sonali let me know that the fire inspector, Tom, came this morning, and he said that he passed. Like she did our fire inspection this morning for the cultivation.
Okay.
Yeah, but they didn't protest the retail.
Okay, we'll look for that from the fire department. But I mean, the point is, right, if we pass it as this, it's relatively technical things and no other punishment. I'm coming around to Mr. Constant, but Ms. Wynn Pearson, do we have the authority to do we can obviously do conditions, we can revoke, we can just say go ahead without any conditions. Can we impose fines?
You impose fines. I believe you have the separate ability to impose fines. I never recall from my presentation previously. Just a second, let me pull it up so I have the code provisions in front of me.
Separate from specific land use, code enforcement, sort of administrative fire fines, we just have the ability to say because of your conduct we are fining X?
Just a moment.
Okay, you can work on that. Mr. Constant.
Yeah, thanks. So there was an assertion made that the state has made a bunch of fines for violations. My question really is to the petitioner and licensee, what fines were levied for what violations?
All right, come on up so you can be heard by the, Barbara.
Mr. Chair, that information should be in the AIM that you have.
I just wanted my words. I'm sorry. I understand the answer to the question. I want it on the record.
So, Mr. Chair, and I just want to make sure that the chair is aware that you're asking for public comment or testimony. And I just want to make sure that you're consistently fair with that in this work session and others.
Yeah.
I have a clarifying question. Is it in fact asking for public comment when you're asking for information from a licensee who's under review? Because I would argue that that is in fact not public comment or public testimony. It's a matter before us that is their interest.
Right. I think it is very different than opening it up for the world, and that can be important too, but has very different interests involved. Barbara or Becky?
Thank you, Mr. Chair. I think it's very complicated because of the quasi-judicial nature of this proceeding before you on Tuesday night. This is not, and I think what I would say is it's just unknown. It's new territory for us.
Yeah, right.
All right, so hold on, back to going in order. We didn't let you finish because we jumped into it, but you described the questions from Mr. Weddleton and their answer, and then this is the other package you have besides the AR, so the fourth is the August 23rd letter from Erica McConnell to AlaskaSense saying that they upheld count 1 and assessed a civil fine of $15,000, dismissed count 2, upheld counts 3 and 4 and assessed a civil fine of $20,000. Count 5 was withdrawn. The license suspended, suspensions were lifted, and they directed that some hash oil be destroyed. Has that been appealed?
No.
Okay.
Mr. Chair, just to follow up then, what is count 1, and what is count 2, and what is count 3, and what is count 4? Because that is not actually in the record before us.
It is in our big 200-page packet. Do you want to answer that?
Yeah, sure. I can give you the nutshell version. Count 1 was the excise taxes. I had to, make my client negotiate a, the Department of Revenue has this tool where you can do a one-time 12-month payment plan. So I negotiated that, and because we negotiated that, we started the negotiations with the Department of Revenue before the actual accusation was served. The board said, okay, we're going to uphold count 1, but we're going to fine you $15,000 for being delinquent in your taxes. And so
What was count 2?
Count two was the business records request. Naughty was.
Okay, what was count 3 and 4?
Count 3 and 4 had to do with the dumpster issue, not allowing access to the dumpster, and then not grinding up marijuana per the regulations completely. That was found outside the dumpster. Count 5 was the one that Erica withdrew. The one that she withdrew. This one was mine.
I don't know that it matters a whole lot because it was withdrawn.
But yeah.
It was withdrawn. It was something minor. I'm sorry. I don't recall.
We could simply want to obtain the state's official charge document with the violation of the counts and add it to the record.
That would be helpful. The question that I'm really driving towards is under counts 3 and 4, what was the actual violation that was upheld specifically, right? Because what I understand is that the violations that were found were not for the refusal to the inspection or the moving of packages of products from the dumpster back into the store, but were only for the mishandling of waste products. And so I would like to understand the nature of those two violations because therein, in my opinion, lies the rub of the question we have to deal with.
Okay, so the charging allegations will get you some of that. Is that in our packet now? I've looked at it, but it's big, or is it something you would provide extra?
It would have to be provided extra.
Well, then wait. So we have a lot of the AMCO materials in there, but not a description of what the specific allegations on the counts are?
Right.
Okay. Is that easy to get from any of you three?
I think we should be able to.
Okay. I'd like that added to the packet. Mr. Weddleton was in line. You want to keep going?
Just one last thing, and that is, it's a bridge, basically. Lays a path for us to talk about the other draft ordinances that have been laid on the table that will, or resolutions, I should say, move to set a proceeding to review all of this information because there is a tremendous amount of information and a lot of moving parts and a lot of lack of understanding of all of the things that have happened to this case. And so it would be, in my opinion, premature for us to take any specific action on Tuesday until we have a full vetting of the details and the questions and facts. And so to me, definitely we should review the second set of documents so we can at least begin that part of the conversation.
Did anybody else want any before Mr. Weddleton?
Okay, 2-1, I told Chris, hey, it's all in here, but I think the state stuff we ran, maybe it's the community economic development, but I didn't see it.
If it isn't, let's get it in. Okay.
Yeah, so, and then a couple things. One, I think Barbara was saying that, asking a question here, and is that a process? When I was on the planning commission, we could ask at the meeting, certainly anybody, anything, call them up, as long as we were all involved. It was having private conversations, you'd have to share that with everyone. So, the petitioner on a rezone or whatever could be called back before we ask a lot of questions outside of their 10 minutes or whatever. Then on Chris's comments, we should have a public hearing. When we met at the Community Economic Development Committee, now we're meeting here to flesh these things out. We could do this all again, but my sense is that's what today was for, was to kind of drill down on this.
Drill down on
ready
this.
for Tuesday.
Drill down on the specific allegations against them. And
give us a chance to get it clear in our heads, so on Tuesday we kind of know where we're headed.
Yeah, Barbara.
So, Mr. Weddleton, I don't know enough about a rezone, but what we're talking about here is on some occasions the assembly acts as a legislative body, and on sometimes you act, as Eric started at the beginning, as a quasi-judicial body. And I don't know what status the Planning and Zoning Commission was in where you asked questions. If you were at an assembly meeting, you absolutely could ask questions of the party, which you were probably in a meeting of the P&Z. This is a work session. There's a little bit of a problem with the definition of a work session in the code, and that's where this discussion has started. I'm erring on the side of caution, encouraging you to be cautious in this new process.
Thanks.
Well, yeah, my impression is that both of you are right in the sense that asking the applicant is always allowed quasi-judicially, and notice and a right to be heard is the fundamental concept of that. So you should do that. The danger becomes if we ask a bunch of people that the applicant has never heard of, didn't know they could rebut, then you get into a whole bunch of areas of being unfair to them. But it's almost never unfair to just ask the applicant their position. That almost never has a prejudice to them. In fact, I can't see how it would. On the AR, and then we'll go. Was there somebody over there who was asking to get in? Did you still want? No, good. Let me know when you do. Just on the structure, and then I want to go to the specific allegations as well. This structure helps. It was a little confusing to me because I ordinarily use a checkbox to understand that a thing has been done, and a blank to understand that a thing has been not done. And it took me too long because I'm getting old to understand that you guys meant it in the reverse. Why not have checks meaning that's an accomplished thing and blanks meaning this is still to be done?
I think the challenge is that pursuant to the code, if you do deny the renewal application, the code 1080 specifically requires that you transmit within 15 days of denial a document to the applicant explaining clearly which code provision you relied upon, and I think the list says in clear and concise language why you found that code provision wasn't met. And so in each of these instances, you're effectively kicking the can down the road and saying, 90 days, hopefully it'll fix it and we can renew the application. But if they don't fix it, you end up with a denial. And so if you do deny on one of these grounds, what we're trying to do is create a structure in this document that meets the requirement of 1080 that you then have specified. And this is the language, this is word for word from the code. You're just saying, this is our reason, we picked this reason. So it's crafted this way just to make sure that it follows the code. It would require some wrangling to try and rework the code as, you're really finding a deficiency, and the code specifically says you have to find a deficiency to deny, these are the grounds of these deficiencies for you to deny a renewal. So we're just trying to create a structure that matches the code and allows you to meet the requirements of the code as you consider an application and determine what kind of action you'd like to take.
Yeah, but this doesn't say has done or has not done. This says the finance department, the chief financial officer shall determine if no such obligations are standing, the chief. And if I check that, I mean you did that.
True. So you could, I think the first section, I guess I was focusing on the second section. You could rework the first section, I believe, to say the municipal clerk has received the following, and then rework it and say you must fill in the gaps, or else your renewal is denied.
Just did it this way to be consistent with what you would have to do in the second portion.
Yeah, because otherwise you've got one where you're checking things that haven't done, the other where you're checking things.
Yeah, and that I did get that.
It becomes more challenging.
But it can mean you complied with all the stuff, the good stuff, and oh, here's a gap you didn't, and then here's the bad stuff you could have done, and I find you did items 3 and 7 of bad stuff. Mr. Gates.
Just at the perspective, the way we look at this resolution is being overcast to the state as well, and so the checkboxes are these making an affirmative motion to approve a test to the state of your license. And you're saying these are the reasons, rather than we're approving this license, and they don't know what's required of check.
All right.
So we need
I
to
don't.
identify-
More on checkboxes.
No,
I'm sorry I
just
brought
wanted
it
to
up.
make sure that I responded to your earlier question before I completely lost the thread, which was regarding the imposition of fines by the Assembly.
Oh, yeah.
The code does specify that the Assembly may impose a civil fine, but only contemporaneously with a suspension, revocation, or license restriction proceeding, which this is not. This is a request for renewal, and it has different due process requirements under the code. So you could institute a suspension or revocation proceeding with respect to these licensees or any other licensees, and in that process also impose civil fines. But there's no provision in the code for you to impose fines as part of a license renewal application.
I can do it when I suspend or revoke,
or
but
restrict. Yeah.
I can't say you've been really bad. We're finding you 10,000, but we're letting you go ahead.
I think we could likely concoct a hybrid proceeding in which you could do both, but there are specific due process requirements written into the code for how to conduct a hearing on something that is a suspension or revocation or restriction process, which are different from the way the code treats license renewal. So I think you would the key would be to make sure that if you wanted to pursue fines, that we created a process that met both requirements under the code as we're trying to shoehorn it into a license renewal process.
Really, Dean? I can't tell if you're holding your arm
I
up.
was just agreeing with Mr.
Okay.
Pearson. I think you really want to keep the procedures separate. The renewal process, which is annual and imposing civil fine for specific violation, which you need evidence to prove and so forth. I don't think you want to make it part of the same process.
Well,
and then when you come up to renewal, you get past violations. You take those adjudicated violations into consideration of whether this is a bad operator that's adverse to the public health, safety, and welfare. So maybe you can disagree, but that's how we see it.
Mr. Peters?
Thank you, Mr. Chairman. So is the only reason that we haven't got a land use certification is because they have outstanding fines?
There was an odor violation that the land use enforcement officer noted in the review. So I went and land use enforcement did show up also, and they can verify that if you like. But the transmittal that the clerk's office received noted that there was an odor issue upon the review.
But so they don't owe any fines to the municipality?
Not to my knowledge.
No, we're going to do it all at the end. Why do you want to?
I just, when you say they, there's two different licenses. There's retail and cultivation, and they have two different.
All right. We couldn't smell at the retail facility is what you're saying. Normal smell.
So I'm going to take this up a notch to a higher view, the more broad question that you proposed.
Okay, then give me,
Second.
I want you to, can we do it in a second? Yeah. So on the license, this particular license, to anybody, where is and how do we view this videotape? Who is it? Is it? I expected a CD in my packet, but is that impossible? How does one do that? Yes, sir. Identify yourself for the record.
I'm Rich Firm with Land Use Enforcement, Municipality of Anchorage. The state is the ones that have video, and we've tried to get copies of. They have a proprietary program that, when the video is loaded into their system, it overrides. We tried to get that, and we couldn't view it. We don't have that program, but we also got from the state was a virus, so we really don't want to put that back in our machine to get it. We had to. It wasn't bad, but it was right about the time the Matsu got bombed, so we were really anxious to put something back into our machine.
Okay, so that's a problem. Anybody have a way that I can view it, or the rest of the assembly members?
Yes.
Do you know how?
We can schedule with Ms. McConnell and go to them and have a meeting there and review the video in sight.
Can we ask Ms. McConnell to present it to us? We can ask. Is there some likelihood that she would do so?
Through the chair, absolutely. Mandy can tell you that she works with AMCO every day, and she communicates with them, and rarely have they denied any request from us. The
then
meeting would have to be publicly noticed. That's the only thing that I would say.
well, I was speaking individually, not as chair, but I would like to see it in a way that doesn't add a virus to my computer or anything else. But I would appreciate it if you would ask the Erica McConnell and the marijuana board for a way that we can all view that. Mr. Weddleton, and then we'll get Mr. Constant wants to raise the level of discussion.
Well, it sounds like we're moving towards postponing the decision, so maybe it's not relevant, but I think at the Community Economic Development Committee, we had a big packet, and it had what I thought were screenshots from that video, and you can kind of track through it, and it lends validity to the storyline that is written out. So without seeing the video, I go, okay, I got the idea.
Okay, Mr. Constant.
Yeah, the issue that chafes me the hardest about all of this was the refusal to inspect and then the actions that followed that were on the snapshots that we've seen. And I would have a question for the attorneys. Can we amend the code to require upon refusal of inspection immediate closure and the beginning of a license forfeiture process? No, it wouldn't, but that's, you said at the beginning.
No whispering.
So you would amend 1080 to state that if an inspection is refused, that the operation is immediately, that they can no longer operate on the license until a hearing is held to determine whether or not. We likely could do that as long as we provided for fairly immediate due process to understand, to be able to provide some courtesy for them an opportunity to be heard on why the inspection was refused, and we'd have to make clear what the grounds were that we couldn't maybe shut down their license and take away their business if the person who, and we'd have to parse it carefully to make sure that we weren't violating due process restrictions. So we could certainly explore the possibility in a code amendment.
We start a little late, and so we can, I think, go till about 10 after, but within the actual 1 to 2 posted time. Did the applicant want to make a brief statement?
Yeah, yes she does. First for the retail license on 2018-253 Espergen. So the retail license has nothing to do with the accusation. It wasn't referenced in the accusation. It wasn't served on the accusation. On section page 3, the last box you got checked there that says such other municipal departments and officials under those conditions set forth in these provisions of this title applicable to this specific license, and it goes marijuana control board completes reconsideration and decision on counts 3 and 4. There was no counts 3 and 4 served on the retail. The retail was completely untouched by this, and Rich can correct me if I'm wrong, but I also believe the retail doesn't have any land use certification issues. So
let me stop you on there. So could I, based on an applicant who had 2 different licenses and had been either found by the state or found by us to have misled inspectors, deny both licenses because we don't want operators doing that, and we rely on certification that they do a whole bunch of things. Could I take an operator's retail license based on them having illegal and possibly misleading conduct in their cultivation license?
Is your question for me?
Yes.
I would say no, because there's no due process for that. You have to actually notice and serve somebody and allege that complaint, and that also wasn't the findings of the control board. If you're asking if that was the findings of the state control board, it wasn't. This applicant's already has $35,000 in fines.
Wait a minute. I want you to present your thing, but all I asked was whether I had the constitutional power or the statutory power to say a licensee who has multiple licenses and has been deceptive and illegal conduct in one license, I can take away another. And you say no.
I say you don't have the constitutional right to infringe on another's constitutional due process rights.
Well, that's sort of circular, but do you want to answer that specific question?
I think that you would have to go through the due process of that specific license and serve that specific license.
So I have no power to say that a licensee with multiple licenses who misuses one, it can't affect the other.
Well, I think you could use that basis to affect the other in a charging document.
Okay. I interrupted you. Go ahead.
Yeah, I would just go on. So I don't understand the basis of the protest for the retail because there has been no action taken on the retail. This license, Smarty's gotten a $15,000 fine and then a $20,000 fine. Her business operations were shut down. Ultimately, for the decision that got reversed by the Marijuana Control Board, so she lost out on about $17,000 worth every day of retail sales for the amount of time she was shut down. How many days was that? 9 days. 9 days. And so, I mean, there is such thing as, there's punishment and there's wrongdoing that took place, and Smarty's trying to deal with the consequences of that and take responsibility for that and totally restructure her business operations. In fact, she had a retail application in front of the state of Alaska as control board 2 weeks ago, and Smarty voluntarily said to the control board, listen, I want to table this application. I want to focus on my 2 locations. I want to make that better. I want to come in complete compliance, and I want to work really hard to do that. And the Marijuana Control Board says, that's a good idea, and we like that you're taking this so seriously. And they tabled her application until December, where they'll come back, and they've even said that, see how you're doing, see how compliance is going for you, see if you've had any other violations. I mean, guys, I drove past 12 homeless people today. This operation employs, I don't know how many people, 35. I mean, I get what you're trying to do, but how much punishment is so damaging that you're just going to create more issues, put 35 people out of work, take out an economic engine that's feeding our economy and we desperately need it. I get it. She didn't do things correctly. She's working on repairing those, but she's already gotten so, so punished, so
So you think she's been punished enough? I got that.
I do. I think she's been punished way enough.
Okay, I got that. I said. Do they share a dumpster?
The retail and the cultivation do not anymore share a dumpster. When they were.
Did they?
Did they?
Oh, no.
No.
Thank
Before
you.
they had tags on each dumpster that said what.
You'll have the opportunity, have had and will the opportunity to re-argue this, Mr. Weddleton.
I guess this is a good time to do it. So I've had some questions on. We got a lot of information. One of these is they notice a violation dated May 4th. And it's page 1123 in our packet. It says on April 17th, it goes around, reported waste disposal, they request purchase history and sales receipts for a wood chipper and video footage of when marijuana product was removed from a secure area and placed out in the open as a test of an employee.
Yeah.
What is this?
So I'll let Lorenzo talk about this. This is an employee that I think that the management team felt may not have been completely honest. So they kind of set him up for a little test to see if he would steal product, if I'm correct. So
True, this was all on camera. We have a DEA cage there in the cultivation. We took a bin of product out, placed it in, of course, the eye of the camera inside of the cultivation, and did notify the person that was in charge of this to see if they would come forth and tell us the truth, if there was any suspect, which we obviously suspected him of something. So we tested his truthfulness to us, and he failed. So he didn't know where it was at, and it took a few days, but we had already put it back into the cage before the end of business, and it was all on camera.
because he was supposed to be doing inventory,
He was doing
right? And so
inventory.
they removed something
for
from
something
inventory.
specific. He didn't find it. He came and said, I think I got it. It's okay. When we knew it was sitting, next to our desk. So, yeah.
Okay.
That's the events of that.
Other comments from assembly members? Lame duck or otherwise? Mr. Peterson.
Thank you, Mr. Chairman. And I just think it's important for the Assembly to try to be reasonable. I can tell you that the people, an average person on the street, if we heard we pulled someone's business license, in essence, gave that business the death penalty for improper garbage handling, they would find that baffling. And I just don't think it's reasonable for us to do that. Maybe they made a mistake. Obviously, they were already fined. I just don't know what more we can ask them to do, and shutting them down. I mean, I know some people say, well, let's discipline, let's be tough, let's send a message. Well, I can tell you the message has already been received by the marijuana community out there, the business community, and you know, I don't think we need to yank this license to scare them anymore. I don't think they're going to be any more scared than they already are. And another message that it sends is to people who might be considering opening a marijuana business in Anchorage. You know, actually, we're closed for business. If we're going to shut somebody down for improper garbage handling, I mean, what, has Dean Warmer got them on extra secret probation? I just think it's not reasonable.
Mr. Constant, and then I have Mr. Welton, and then me.
So, while I'm not advocating the taking of the license at this time, I object to the framing of this about an issue of improper garbage handling. The thing that is crystal clear to me is that there was a refusal of an inspection and then an immediate opening of the dumpsters where products were moved from the dumpster into the facility. And then the actions were that they emptied the dumpster and had the inspectors back, whatever order that took place in. All of that lends itself towards a broader statement of action, not just, oh, they failed to dump their marijuana properly. And that's the question I am hopeful that we get really deep into and sort. Because what I'm hearing from the retailers out in the community is, if they can do this, then we don't have to follow the rules. Because they've proven there will be no accountability in Anchorage. That's the piece that I'm hearing from members of the community who are in the business. Like, if there's no accountability for this action at the local level, then the standard we set, the benchmark is, it doesn't matter.
No, we've done with that. Mr. Weddleton and then me.
Maybe continue on that at some peril, because of course I got in trouble for someone who did throw stuff in a dumpster, and now we're going to get somebody here who failed to throw stuff in a dumpster. But if there were a liquor store that had left, you know, a little case of shooters or something, or a six-pack next to their dumpster, they'd have some serious big trouble. And that's what they did here. They left pot out. Somehow, pot from this establishment was left out. And I think we're putting some small amounts, and just cumulatively added up to that amount. For a 10-year-old kid, that's a bonanza. And when kids are starting to get pot from these places, your industry is going to be shut down. And that's what happened here, is you open the door for that. And I think that's very, very serious. This is not a small thing of pure trash mishandling. It's very, very serious. And it's hugely risky for your industry.
Yes, so me, and then we're right at 2, so unless there's other assembly comments, we'll wrap it up. But I just very much disagree with Mr. Peterson. This is not a trivial violation, and I think it trivializes it to call it a dumpster. When you're having an illegal intoxicating product, what you do with it is very important. And a business that until 3 years ago or 4 was a felony, and still has serious concerns amongst the community, I think that trivializes it unfairly. Both the violation itself, because disposal of this product is an important end to the chain, and then doing that improperly. But as worrying, and I've seen the allegations, and I've seen the stills, and I'm still trying to see the videotape, so I haven't made up my mind, but the allegations and the fact that fines were paid based on those allegations and what I've seen of it, we have to have a level of trust that when they say they have done things, it has happened, or the whole documentary process falls apart. When they swear that things have been done, and we take that as a deal, when we find it hasn't been, that we've been lied to, we need to have a serious consequence. Somebody said we want to send a message. I don't want to send a message. I'd prefer not to. But I think we're going to send a message either way. What we do is either going to send a message, do whatever, or this is serious. And if we have to send, we should do the appropriate conduct for the public safety risk that was involved for these violations and for the way this operator has acted. but the message we send it needs to be one that we are serious. This is a serious issue, and we'll treat it seriously.
So, if I might, thank you. There is a separate set of resolutions laid on the table that effectively recognize that there are potential grounds for non-renewal that we don't know if we're ready to do at this time, but that we communicate to AMCO that we are lodging a protest and we're going to take an amount of time to review this process. And that would be basically, if you look at page 2 of either of those resolutions, the Assembly enters this protest and that approves temporary license until X date, 60, 90 days, which if we did pass either of these two or both of these two, I would be asking legal counsel to outline a process by which we go through this that recognizes and protects the due process rights of the petitioner and creates a fair and equal process for the public. And so I am going to be asking folks to move forward with these two items laid on the table, because to make a decision on these items, I think we're underprepared. We will do the public an injustice if we do.
Slightly after 2, we started somewhat after 1. Any other comments from Assembly or staff? Great, then I will adjourn the work session.